Ever looking for justice, Glendora filed her petition for rehearing. To nobody's surprise, it was denied. And now, folks, we go into why should this petition for writ of certiorari be granted. This is to the United States Supreme Court. We are taught in school that if you are wronged, you go to court and seek justice. This is not what happened. And you must teach the judges below the lesson. You have to stop judges who rule for what is best for judges. You, this is being the United States Supreme Court, you have to teach judges to do their work with this mission in mind, to do it truly to their oaths and gloriously in the tradition of the United States Constitution. Glendora's husband, now 75, is a veteran of D-Day, June the 6th, 1944. He was not there on behalf of a crooked America, lying, covering up, eschewing responsibility and duty. A United States attorney is there to uphold justice and honor, not to slaughter it with her selfishness. What happened is un-American against democracy and contradicts the best in the Christian heritage and the Judaic meditations. The United States Supreme Court must peruse the dismal chronology. What Glendora said happened did happen. The worst injustice done Glendora is that she was denied due process. The process mandates an unbiased, impartial judge, free from any personal interest in the verdict. Judge Cattell stood up for the two judges and stood against Glendora, and he did this to the embarrassment of the whole court system. Judge Cattell's proclivities for the defendants showed up early in ignoring an obvious default. The summons with notice was served on March the 30th, 1993, with 20 days to answer, and these 7 defendants never answered at all, not in April, not in May, not in June. On July the 12th, 1993, Glendora made a motion for default judgment. Defendants never opposed Glendora's motion. How could Judge Cattell be deaf, dumb, and blind to a default of this magnitude? It was unfair to Glendora that her case, which he paid $245 to get into New York State Supreme Court, Westchester, was yanked out of Supreme Court and put into United States Bankruptcy Court. Glendora got it remanded to state court once, and then the United States Attorney yanked it out of state court again and ping-ponged it to federal court again. Why? Because defendants knew that another federal judge would stand by them and protect them. This was outrageously obvious and shamefully a denial of due process. The fourth injustice done Glendora is Judge Cattell's being so anti-pro se. This is against the Constitution of the United States and against his oath to support the Constitution. He even states in the New York Law Journal that he will not allow an oral argument by a pro se. He is not running a court, he is running a correspondence school. Glendora has reason to believe Judge Winter, Jacobs, and Cabranes were not fully aware of the facts and circumstances, nor cared a bit about same. 5 minutes was not enough to cover all the arguments against what happened to Glendora. She asked that Judges Winter, Jacobs, and Cabranes read all of her brief. All the points she wanted to make were in her brief. And her life depended on their reading every bit of them. The loose paper thrown into the envelope with Novinsky's brief was improper and should have been struck from the record. This case was not about the IRS. This is an error by Novinsky. It is titled 28, United States Code, Section 1346B. So here's what they should have done. It was B, not A. A is about income tax. Hall, Duberstein, Jones, Maloney, Kavanaugh, Mann, and Derby betrayed the public trust. Judge Cattell protected them instead of the injured citizen petitioning her government for redress. Is this the best they can give their country? Is this the best they can do for the money-back taxpayers' sacrifice? Here's my husband, 75 years old, who was in D-Day, who offered all he has, his life, to his country. But he didn't give his all for the kind of a country these defendants are giving us. To this day, nobody has dealt with the merits of this case. There's negligences and defendants perpetrated and the injury they caused. It has been all penumbra and no core, all procedural. The gravamen has never been addressed. Judge Cattell has now migrated to Connecticut with his hand on the knob of the retirement door. What do? We reverse his decision in its entirety and face the negligences these defendants caused plaintiff. Award plaintiff $50,000 damages, compensatory and punitive. Tax her costs to the defendants and award her what other reliefs this court deems proper. Remember, the negligences of these defendants led to 3 spin-offs for $31 million, $181 million, and $292 million. When the Nassau County Feds, Glendora has reason to believe, pressured Cablevision to censor her TV program and take it off the cable, thus violating federal law, Title 47, United States Code 531E, and state executive law, Article 28, Section 829.3. The same program is on 10 other cable systems. About the shameful papers by the United States Attorney's Office, it is very sad to see the people in charge of protecting citizens from those who act dishonorably themselves behaving dishonorably. First, Glendora is a victim of Scott Lord, then of the bankruptcy court, and then Judge Cattell. Tell me where this fits in with liberty and justice for all. Judge Cattell dismissed the complaint because Glendora had not filed the administrative claims. She filed the administrative claims. All were denied, no great surprise to anybody. She cured the defect that is clearly Federal Rules of Civil Procedure, Rule 60b-5. It is no longer equitable that the judgment should have prospective application. And by the way, this dismissal could not be with prejudice. And the Federal Rules of the Federal Tort Claims Act says that. What you read here has been read on television. The public has to know the truth about the performance of the people charged with protecting society. Before filing her motion to vacate and reconsider, Glendora gave defendants a month to face what they had done and make good, but they ignored it because they knew old buddy GLG, Gerard L. Cattell, would take care of them. Just make good and it will go away. When O'Connell paid up and said he was sorry, it went away. Otherwise, it will smolder on TV forever and never go away. Do you know that Judge Hall finally did the right thing? He recused himself and asked that another judge be assigned to the bankruptcy case in which Glendora was creditor. Judge Holland thereby came on the case and made quick work of finalizing it, and Glendora got her payment of $3,005 less than the panel trustee got. Yeah, the panel trustee got it. Yeah, the panel trustee, the lawyer, made more money than I did. Well, you know, this is what we expect, right? Defendants have no defense and never will have. Let me repeat, defendants have no defense and never will have. Glendora should really sue Judge Cattell for the same cause of action she sued Judges Hall and Duberstein. She has been bullied by all of them. Judge Cattell called Glendora's case a comedy of errors. Believe me, I see nothing funny about it. In the same paper, Judge Cattell wrote, fortunately, quote, some sense was inserted into this chaos by virtue of bankruptcy Judge Howard Schwartzberg's remanding the case to the state court as being imprudently removed to the bankruptcy court. While we have no doubt that we have not heard the end of this case for the time being, there is no proceeding pending here. And the motion of the federal defendants for withdrawal of reference has been mooted. There being no further proceedings pending, this action is dismissed. So ordered, dated White Plains, New York, June 7, 1993. Glendora says to you, this is more pro-judge sentiment. The bankruptcy code, law, and rules say that a bankruptcy judge by the Judicial Conference of the United States should possess and have a reputation for integrity and good character, be of sound physical and mental health, demonstrate commitment to equal justice under the law, and exhibit judicial temperament. The record shows that not one judge in this odyssey met the test. Not Hall, not Duberstein, not Cattell, not Winter, not Jacobs, and not Cabranes. It is ludicrous in the extreme that the federal defendants stalled with blunder after blunder. Withdrawal of reference when there was no reference. 30-day extension once, 30-day extension twice. Foley Square when it should have been White Plains. Removal out of Supreme Court once, removal out of Supreme Court twice. Letter 1 instead of a legal paper, telephone call instead of a legal paper. Letter 2, letter 3, letter 4, telephone call 2, and a July 16th adjournment. Judge John Robert Hall was bad to take a year to make a decision about vacating more than a dozen defaults by debtor Scott Lord. Judge Robert John Hall was a bad judge to ignore Glendora's right to motion him to request the United States Attorney Andrew Maloney to conduct a criminal investigation of Scott Lord, Jeffrey Barnes, and Jan Stahl. Judge Robert John Hall was a bad judge not to hear Glendora's evidence when she stood before him and to shut out her information. Judge Robert John Hall should have recused himself 4.5 years before he finally woke up to this fact and did it. Judge Conrad Duberstein was bad to ignore and to do nothing about these injustices by Judge Robert John Hall when Glendora informed him every week what was going on. Judge Gerard L. Cattell was bad to ignore the obvious default of defendants Duberstein, Hall et al. In not answering a summons with notice and complaint in 20 days, yea, in 3 months, and to be deaf, dumb, and blind to a default of that magnitude. Judge Gerard L. Cattell was bad to deny Glendora's just and correct motion to vacate and reconsider when his judgment had no prospective application. He dismissed her case, and the Federal Tort Claims Act says this has to be a dismissal without prejudice, because Glendora had not filed the administrative claims. Then Glendora filed the administrative claims, all denied because of more judge buddyism. Therefore, Judge Cattell's Judgment, Federal Rules of Civil Procedure 6012B had no prospective application. Glendora notified Judge Cattell a week after his decision to dismiss in August 1993 that she was going to file her administrative claims, and he was silent about this for 9 months. Then is when Judge Cattell should have said what he waited until April 1994 to say. But that's if Judge Cattell is doing his job as a judge, litigating on the basis of what the law says. But he wasn't. From the beginning, he knew he was going to protect his two buddy judges, Hall and Duberstein. He knew from the beginning how he would rule, and then he makes up the reasons for it. Why? Judge Cattell's decision was premeditated, rigged, stacked, and fixed. He knew from the beginning he was going to rule in favor of his buddy judges by hook or crook. Judges Hall and Duberstein knew they could count on him. Judge Cattell was bad to deny Glendora due process. A judge should be unbiased and have no personal interest in the verdict. Judge Cattell was wrong to lose Glendora's motion and to use a dry-run copy that had no dates on it. It's a good thing Glendora had her stamped copy as to when the real one was filed. Judge Cattell was bad to be so blatantly anti-pro se as to print in the New York Law Journal every day no oral arguments by a pro se. Judge Cattell is bad to have no conferences, no hearings, no trials by jury, and to reduce a court to a correspondence school. How anti-due process can one get? Glendora petitions her government for justice, honesty, principle, and she gets corruption, violation of her rights, and buddyism. She doesn't have a chance, and she has to pay for this, $1,000. Courts and judges are the worst consumer ripoff in America today. Before we do the last 10 pages to the writ, the petition for writ of certiorari to the United States Supreme Court, translated is, you're asking the Supreme Court for permission to bring your case before them. You don't have that right. It's not a right. It's a matter of their discretion. Now, let's see. In Buffalo, they have a park named Humboldt Park, Humboldt. And the mother said to her child, "What did you learn in Sunday school today?" And the child said, "I learned that Jesus sneaked through Humboldt Park." So the mother talked to the Sunday school teacher, and she says, "What did you teach the children today?" And the Sunday school teacher said, "I taught them that Jesus had a meek and humble heart." What is a judge's life worth if he stands up for what is wrong, not right? When he desecrates his oath, it is time for reform, for change. Judges rule for what is best for judges. After all the lofty reading, research, and case citations, judges rule by the seat of their pants anyway. Glendora's action showed up these judges, exposed them, made a public record of the bads. It is there in the archives forever. It is on television every week. Judge Winter was bad to ignore Glendora's request for 10 minutes of oral argument instead of 5. This was the first oral argument she had had since she filed the lawsuit March the 30th, 1993. It's the first time I ever faced a judge, eyeball to eyeball. Judge Winter was bad to take Glendora's request for 10 minutes out of her 5 minutes. Then and there, Glendora could see that Judge Winter was not interested in justice. Then and there, Glendora could see that Judge Winter would commit the evil Judge Cattell committed, cover up and protect his buddies, Judges Hall and Duberstein and Cattell. The cycle is complete now. The vortex has reached its nadir. Now we know Judge Winter would not give Glendora 5 minutes when the calendar was grotesquely short. A motion and 3 oral arguments was all that was on the calendar. When the panel arrived at 10 a.m. straight up and was out of the courtroom at 10:59 a.m. and he couldn't give Glendora 10 minutes instead of 5. Little is left to the imagination on that one. It is a sacrilege. Are you going to the funeral of Madam Justice and of Sir Court Reform? Glendora knows she fought the good fight. Glendora knows she still owns her soul. The oral argument was September 27th. The decision was September 28th. No deliberation. No due deliberation was had. The third paragraph at page 2 of Judge Winter's decision is illegible. Can you read that? I really can't read that. And this is the United States Court of Appeals, the second highest court in the United States. Glendora did exhaust certain administrative remedies, quote unquote, pursuant to Title 28, United States Code 2675A. To say she did not is a lie, the same lie that Judge Cattell told. Glendora cured the defect. The record stands. This decision by Judge Winter is so bad, it should be framed and put on Glendora's office wall. Certainly Glendora was framed. An appeal panel will not ask questions of a pro se. An appeal panel will not even look a pro se in the eye. Why? Because of the unconscionable prejudice against pro ses, the due process denial of a pro se. Lorraine Novinsky, representing the United States Attorney's Office, declared on one hand that the, quote, resolution of this case depends on New York State tort law, and on the other hand, she is the one who asked that the case be removed to the United States District Court. Judge Cattell wrote about judges who are vested with certain immunities. Well, this is more judge protection. This is more denying Glendora's due process. There was a big case brought against Judge Hall in 1985, so much for immunity. This case has rolled over 2 Independence Days and almost 2 Armistice Days. It is a sacrilege that defendants cover up instead of fess up. And then the knife is turned in all the wounds, excruciatingly. Novinsky submits a bill of costs to Glendora to pay $122 for the printing of her brief. Novinsky's brief was 6 sheets on 2 sides. This equals 12 pages times 10 copies, or 120 pages times 2 cents per page equals $1.40, plus 5 cents per cover times 10 equals 50 cents, and that's a total of $1.90. She asked me, not demand, the law, I guess, said that I had to pay the cost of printing her brief, $122, and if I had had the brief printed, it would have been $1.90. And then the rest of this about this, you have already heard. Glendora does not have to pay for a service when she had no opportunity to shop around and get an estimate. See, this is crooked, and this is coming from the courts. Glendora does not have to pay for a 1 estimate bill. For $2, Glendora could have had this job done. The United States Court of Appeals accepts briefs that are on photocopies. Glendora has had 14 briefs accepted by the United States Court of Appeals, all photocopied. There is nothing that demands a rip-off printing job by the United States Government Printing Office. The United States Government Printing Office should be giving people a lower rate than civilians, not a higher rate, and a rate that is $122 divided by $2, or 61 times what a consumer rate is. How dumb does Novinsky think people can get? Glendora said all along the courts are the worst consumer ripoff there is. The United States Government Printing Office, of all people, should be environmentally aware enough to make 30 unneeded copies. This is an outrage. And the United States Government Printing Office should not be ripping off taxpayers. Who runs his agency? Glendora is a senior citizen, 66 years old. Her husband is a senior citizen, 75 years old. Scott Lord rips off Glendora for $4,600 and goes bankrupt. Glendora waits 4.5 years for incompetent Judge Hall and his boss, Judge Duberstein, to settle a simple bankruptcy case. Then, instead of having time for business, Glendora has to use her time and resources to fight Scott Lord, the bankruptcy court, and Judge Cattell, who ruled for his buddy judges. Finally, Judges Winter, Jacobs, and Cabranes have to side by their buddy, Judge Cattell. Hence, Glendora has no income from her business. She and her husband, Franklin, have to live off his pension and their Social Security checks. A rip-off of $122 is a hardship. If Novinsky is going to be dumb enough to pay $122 for a $2 job, then let her pay the bill. Not only is there no due process, a judge should be unbiased and have no interest in the verdict, there is also the injustice of making a person pay for no justice. There is also the injustice of making a person pay for no justice. It certainly gives Glendora a lot to talk about on TV. It is no wonder so many judges, lawyers, clerks, and others watch a chat with Glendora every week. Novinsky gets her grubby Shylock request in early. It arrives before Glendora's rehearing arrives. Novinsky should wait to see if the 3 judges are going to change their decision. After Glendora's rehearing, she gets her grabbing hands out October 5th, the same day Glendora is sending out her rehearing. Glendora is going to read this paper on Janet Reno's hotline on numbers 1, 2, and 3, government reform, somebody in the Department of Justice who has done wrong. Every day it seems there is a lie or an injustice, some court ripoff we have to defend ourselves against. Every day we have to get out a legal paper defending ourselves against the voracious. And Glendora is left with no place to go to appeal this ripoff. Madam Justice is dead, and Circuit Court reform too. After this poignant plea, the United States Court of Appeals, Second Circuit, granted this heinous cost of $122. Glendora asked the United States Supreme Court, on the basis of the same plea she made to the Second Circuit, to vacate this cost of $122. Certiorari, which should be, certiorari comes from the Latin word, quote, to certify, unquote. Glendora wants the United States Supreme Court to certify that all the decisions by Judges Winter, Jacobs, Cabranes, Gattell, Duberstein, and Hall were wrong. Glendora wants you to certify that she was and is correct. March the 30th, 1993 to the present, 1995. And there's the word, there's the definition from the dictionary. Therefore, Glendora's wherefore of so many papers in previous proceedings stands. Therefore, Glendora's wherefore of so many papers in previous proceedings stands. Because the district court improperly denied plaintiff's motion, its order should be reversed. The issue presented for review is whether Glendora received justice from Judge Gattell. Glendora didn't receive justice. Glendora asked this court for $50,000 damages for injuries incurred by the negligences of the defendants. Glendora asked that defendants be taxed for the cost of this action, $120 filing fee plus $110 appeal fee. And all of the printing and postage costs aren't in there. Glendora asks for any further relief this court deems just and proper, dated White Plains, New York. Subscribed and sworn to on the 10th of January, 1995. To Lorraine Novinsky. And starts the exhibits, folks. The appendix. We call them appendix. That's Appendix A, and you know all of these. All of the decisions, the wrong decisions, the unjust decisions, the selfish decisions, decisions that violated their oath of office and their duty as judges, because these have all been read to you. So now the U.S. Supreme Court is reading them. And I included in this that paper that I read you practically every week about bad judges, bad lawyers, and also the Americans for Legal Reform. This went out on Tuesday, January 10th. And we got it out on our way. This went out to the United States Supreme Court on the way to Small Claims Court in Manhattan against Michael Gelman for $120 for not returning the VHS and for destroying my property or losing it. It's the same. There's nothing more to report on that. As to what will happen, I guess you'll find out as soon as it happens. And I called the United States Supreme Court. The clerks there are very good. And I always have my questions, and I have my rule book for the rules of the United States Supreme Court, and I ask my questions, and the clerks answer them very, very well. And I answered, I asked for 3 questions, I think, the last time I called, and it cost me $1.60. So it's kind of expensive. Now, I do believe that is all of the happenings on Glendora versus Scott Lord and all the other people whose names you see on the screen right now. And now for the comic relief. The 7-year-old ran into the house and says, "Grandma, Grandma, I dropped my lunch bag in the driveway and Daddy backed the car over it." And Grandma says, "That's Wheels on Meals." Now, this group of women, same group of women, used to meet in this one woman's house every week. And they always met in the same room. And it was the same group of women. And one week they came and the room looked terrific. And so one of the women said to the hostess, "What have you done to make this room look so much better? Do you have new curtains?" The hostess says, "No." And another woman says, "I know, you've got new wallpaper." Hostess says, "No." And a third woman says, "I know what you did to make this room look so much better. You got new carpeting." Hostess says, "No." And finally, all of the women, practically in unison, said, "What have you done to make this room look so much better this week?" And the hostess says, "I took down the ironing board." And that brings us, folks, to what happened on Glendora versus Cablevision, Charles Dolan, John Tata, Francis Randolph, Mark Lustgarten, William Quinn, William Bell, Joseph Osnara, and all the other names that you see on the screen. Big news. Big news this week, folks. Yesterday afternoon, which was Wednesday, I was just getting ready to go edit at White Plains Public Access, and the telephone rang, and it was Clerk Frank in the United States Court of Appeals, Foley Square, Manhattan. And he says, I have good news for you. He said, your case, the decision of Judge Bryant has been vacated and remanded to the United States District Court. Now that's Glendora versus Cablevision. Whoopee, hooray! Can you imagine that, winning a case in the United States Court of Appeals? And now that's Glendora versus Cablevision. That was the first lawsuit I filed against Cablevision, and that was in December of 1993, and that was following the telephone call that I got that they had taken my program off of the cable TV, thereby breaking a state law and a federal law. And so I brought a freedom of speech case in the United States District Court, and Judge Bryant was the judge, and Judge Bryant dismissed my case because he said I didn't state a cause of action upon which relief could be granted, and Judge Bryant is wrong. So the judges on the United States Court of Appeal who ruled in my favor are Judges Minor, McLaughlin, and Van Grafelen. It's a freedom of speech case. Cablevision violated my freedom of speech. So stay tuned to see what happens next week on going back to the United States District Court and having this case handled correctly. Kalaji's big argument was that that Cablevision hadn't acted under color of state, and I said they had. And so did my amicus curiae, I, Robert Perry, and Brian Grafman. So it's very interesting what's going to happen next. And guess what? That's the second case that Robert Kalaji, big Park Avenue lawyer down in Manhattan, he lives in Rye, second case that Robert Kalaji has lost to a pro se. This is the second case, Cablevision people out there, that you have lost to a pro se. Let's see, what other news is there on Cablevision? 5 hours on Cablevision last week, and I only spent $4.67 on Cablevision last week. Time last week was spent on Michael Gelman finding the evidence on the audio tapes that he did what he did, and let's see, and a lot of it was spent on the United States Supreme Court, which we just read you. You can see why that took a lot of time. And 12th night, we started taking down the Christmas decorations. That's Epiphany. Epiphany starts on January 6th, 7th, all to Easter. Epiphany lasts for a long time. I filed 3 lawsuits against Cablevision. Number 1 is the one that was just won. that he did what he did. And let's see, and a lot of it was spent on the United States Supreme Court, which we just read you. You can see why that took a lot of time. And 12th night, we started taking down the Christmas decorations. That's Epiphany. Epiphany starts on January 6th, 7th, all to Easter. Epiphany lasts for a long time. I filed 3 lawsuits against Cablevision. Number 1 is the one that was just won. My appeal was granted in the United States Court of Appeals. Number 2 was the case in state Supreme Court where Cablevision broke the state law by taking my cable program off. And Judge Silverman ordered them to put it back on again, but he didn't make them pay any damages. And that's really dumb, because they broke a state law. You know, they just can't go away scot-free. Well, they did. They walked off scot-free. So I've appealed that part of Judge Silverman's decision, and that's in the appellate division. And then lawsuit 3 was because Judge Bryant ignored the federal law of censoring a cable TV program, public access. Judge Bryant ignored that, and so I had to bring a 3rd lawsuit, and that was in the United States District Court. And Judge Broderick got that, and he made a mess of that, and that's going to the United States Supreme Court. So those are the 3 cases. I had 3 lawsuits against Cablevision, and 2 of them are won. And so a Great Big Park Avenue law firm lost, Cablevision lost, and a pro se won. Now something else to tell you. Going through all of these audio tapes for Michael Gelman to find that evidence takes me back to conversations of 1990, 1991, and 1989. And I've come across several conversations with Charles Dolan. I used to talk to him every month. And they're very, very nice conversations. I used to like Charles Dolan a whole lot. So that's very, very interesting to hear those from those years back. What else to tell you? Something else went through my mind. Oh yeah, the appellate division. New York Supreme Court, 2nd Department. They're in Brooklyn. And they cover your courts. You and I have the same appellate division, Nassau County and Suffolk. And they denied. I can't understand how they can do this. They denied my motion to vacate Judge Silverman's order to rob me of my costs, which is a New York state law, and to gag me from contacting the Cablevision defendants. How can they do that? And I got a good idea who is doing it. Who is always saying no, no matter what, and making himself and the whole appellate division look bad. I just got a big idea as to who is doing that. Because I see him at the oral arguments, and he'll never look me in the eye. He always puts his eyes somewhere else. And he's been on the panel practically every decision that the appellate division has made, and they made every one against me. So we're going after that one in a big way. You can even go to the United States Supreme Court on that, on the basis by color of state that they denied your rights, your civil rights. So we might just go after those judges, or that particular judge. Now, they also denied, and give me one good reason they could possibly have for this. They denied my motion to drop Thomas Garger as a defendant. Why? How could the Cablevision and these defendants possibly be prejudiced or harmed in any way just to have Thomas Garger dropped from the action? Just tell me how. And then the decision that came through was all garbled, and it's all mixed up, and it said that I was appealing an order, the gag and rob order of Judge Silverman. I'm not appealing it. I'm making a motion to vacate it. And the paper's just full of error. Full of error, full of error. And I talked a long time this morning to Martin Brownstein about it. So we'll see what becomes of that. And I'll have to start writing my appellant's brief very shortly on the why Cablevision should pay damages and why they shouldn't have been let off scot-free. $1.5 billion corporation who goes out the next 3 or 4 weeks and buys Madison Square Garden for $1.5 billion. One, Judge Silberman lets him not pay costs of $800, and two, Judge Silberman lets him go by without paying a fine for violating state law. Now, what kind of a court is that? I learned at the United States District Court yesterday that Judge Broderick came in for 2 or 3 days, and he hasn't been in since. And here he is tying up the biggest courtroom that's in the United States District Court in White Plains. And here we are paying all that salary and all those clerks and everything else. A judge has to have a sound body and a sound mind. As a litigant, we are entitled to that. So I'm bringing you into what's happening on Glendora versus Gannett, Broder, Curley, McCorkindale, Watson, Sherlock, and Paulson. The week of from January the 5th to January the 12th today. Nothing's happened, but I'll tell you what's going to happen. I'm getting out my petition for writ of certiorari, and I'm going to the United States Supreme Court, and I'm going to show them that Judge Broderick's decision was wrong, and it was an unable decision, and so that's where it's going, and nothing else is happening on that. Judge Broderick was the judge on that, and the case was about Gannett being antitrust in Westchester and Putnam and Rockland. We all know that it is. Name me any other daily newspaper. And all of the things they do wrong because they are an antitrust, and how they injure you, and they injure me, and they injure the whole community. And named Doug was driving his car, and he wasn't familiar with the road, and it was foggy, 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 and he couldn't see, and he was so scared that he was going into a ditch. And up ahead, a car pulled into the road, and it had nice bright taillights. And so Doug says, oh, he must know the road. I'll just follow him closely, and that'll keep me from going into the ditch. And this went on for a long time. Followed him for a long time. Finally, the car up front suddenly stopped, and Doug hit him. And Doug got out and says, why did you not give me a warning that you were going to stop? Why didn't you give me some kind of a signal? Why didn't you give me some kind of a warning that you were going to stop suddenly? And the man up front said, what, in my own garage? Now I have to tell you about, let's see, the DHCR and Judge Coppola, the two DHCRs. I'll just go over the case again. The landlord charged me twice the amount of rent that the Emergency Tenant Protection Act allowed. And so I went to the New York State Division of Housing and Community Renewal, and I got a refund of something like $5,000 that the landlord had overcharged me. So the DHCR did a good job. But there's a law. The Emergency Tenant Protection Act says clearly that if a landlord cannot show that he did not do this willfully, in other words, if the landlord can't prove that this was not a willful action on his part, then the tenant gets a triple damage award. And this is where the DHCR broke their own law. They did not award triple damages. I was injured. It's an amount of money of about $12,000. And so I went to the Westchester County Supreme Court for justice. And what did I get instead of justice? Judge Coppola, who ruled in favor of the DHCR. And then Judge Coppola told him to submit an order for him to sign, which is a sloppy way to do it. A judge should say, so ordered, and that's it. All right, there's a state law that you have to submit this order to sign within 60 days. If you don't, the judgment is vacated. Well, the DHCR, in its madness and its confusion and in its ineptitude, did not send in the order to be signed until way after 60 days. So I went to Judge Coppola and I said, your order is vacated, because they didn't make it. And what did they broke a law, and what did Judge Coppola do? He let them break a law. He himself broke the law. So Judge Coppola broke New York state laws twice. And then there's another law that a landlord cannot harass you to move under the Emergency Tenant Protection Act. And if he does harass you to move, he's to be fined $1,500 for the first offense and $1,000, I think, for the next offenses and so forth. And this landlord did harass me to move 13 times. I have it all on audio tape, and it's about $13,000 or $14,000 worth of damages. I took it to the DHCR down on William Street, which takes care of says they take care of the harassment cases, and they broke the law. So now you have the New York State Division of Housing and Community Renewal breaking 3 of its laws. And you have Judge Coppola breaking 2 laws. Oh, and that case got before Judge Coppola, and he ruled in favor of the DHCR. So he really broke 3 laws. And so that case is before the Appellate Division of the Supreme Court, 2nd Department in Brooklyn. And then the worst thing of all is that Judge Coppola got reelected, and he's with us for another against us for another 14 years at a salary of something like $113,000. Mother said to her daughter that she should get married, and the daughter says, "Why?" And the mother says, "Because there are just some things you can't blame on the government." And a mother and a father took out their young son to a posh restaurant to give him an experience of eating in an expensive restaurant. And so when the waiter says to the little boy, "What did you want to order?" and the little boy says, "A peanut butter sandwich." And the father says, "No, no, no. Order something that you've never seen before." And the little boy says, "I never saw a peanut butter sandwich before that cost $9. And the young man went to California to seek his fortune, and he wrote home to his father, "I got a job, that's a feather in my cap." And a little while later he wrote home and he said, "I got a promotion, that's a feather in my cap." And a little while later he wrote home, he says, "I got a raise, that's a feather in my cap." And it came time for the Christmas holidays, and he wanted to come home, and he called up his father and he asked him to send him the airfare, and his father said, "Take some of those feathers and fly home." On Glendora versus Lydia Gallicano on Saturday, I took an hour and a half to videotape it and edit it last week for the TV. And then on Saturday we wrote out what happened on Wednesday in Judge Freya's courtroom, 4:30 to 5:30 p.m. And when Lydia didn't show, we spent 9.5 hours on Lydia this week, and we spent $1.50. And nothing came in to balance that off. Now, on Monday, I typed my objections to Lydia's letter to the court. I have to read it to you, and read the Judge Freya decision, which came along very speedily. And I have to make a decision whether to send this log out. Most of the days have been spent in the Michael Gelman tapes, the audio tapes, and getting the thing ready. Scott Lord for the United States Supreme Court. What happened in Small Claims Court? Judge Joanne Freya, January the 4th, 95, Wednesday, 4:30 to 5:30 p.m., White Plains City Court. Franklin and Glendora arrived at 4:30 p.m. The courtroom was packed. 20 people were standing. The clerk, Trudy, told us to sit down at the defendant's tables, 2 chairs. Franklin gave his chair to a woman who was standing. Judge Freya went through the calendar 4 times. She does very well. At 5:20 p.m., Judge Freya called our case. Note, the claimant, Lydia Gallicano, did not show. There was another matter not scheduled on the regular calendar motions. Lydia Gallicano versus Glendora Buell was called out. Is Ms. Gallicano here? No answer. Okay, let me first of all, Judge Freya says, this action by Ms. Gallicano on or about October 19th, not on or before us until April. The defendant, Glendora Buell, made a motion to this court and a counterclaim. The motion is going to be granted. It's going to be granted on 2 conditions of the Uniform City Court Act, Section 1808 and Section 1810. What is res judicata? Section applies to Ms. Buell, and that is Section 1808. I'm relying on that, the claims preclusion. the judge to Glendora. I don't know if you had a chance to look at the letter from Ms. Gallicano. Take a look at that and read it as well as the motion. Glendora, that was never served on me. This is the letter from Gallicano to Lydia Gallicano to Judge Freya. Judge Freya, it wasn't? Glendora. Judge Freya, excuse me. It arrived earlier today or yesterday because it was on my desk. It is neither here nor there because her arguments are not persuasive, because of the traditions of the statutes. Let me clear res judicata under Section 1808 precludes this claim. Let me make it clear. Res judicata under Section 1808 precludes this claim. That was what was in my motion. And also, there's an issue on collateral estoppel if you want to view that separately, because the case was heard in landlord-tenant court by Judge Holden, and then on appeal to the appellate term, the decision was reversed. And as a matter of law, by the Real Property Actions and Proceedings Law, Section 711(2), which required a demand, it's statutory to going into the commencement of the action. When the case was reversed, when the judgment was reversed, the case was effectively dismissed. This is Judge Freya talking. It was, in my opinion, precluded from all claims and actions. From small claim action, and that would be also Section 1810, which is a prior adjudication of a case. And that was the law that I quoted in my motion to dismiss this action brought by Lydia Gallicano. It is my decision, Judge Freya said, and I will write it as a decision when I get to it. Glendora, oh, you're going to write a decision? Judge Freya, I'll do a short form. I didn't have a chance to do it. Someone, you have a right to hear my thoughts. My decision will be very short and succinct. Your counterclaim is going to be dismissed as well because of jurisdiction. Small claims actions are for the recovery of money only for a sum certain, which is now $3,000 limit. The basis of your counterclaim was really infliction of emotional distress and also some of the arguments made under Section 1810 itself, which is harassment. This is really the basis. 1810 is really the basis. Freya says this is really the basis. 1810 is really the basis for keeping cases out of our court, not keeping them going in our court. So the nature of your counterclaim are not appropriate for small claims. They don't speak of money judgments. They are not based on any sum of money as a basis rise to the level of equity claims. That is really not the jurisdiction of small claims. While we can grant a decision on an equitable claim, equitable theory, your counterclaim is really retaliatory in nature, and I think the relief from Gallicano's payment is enough. Glendora, I wasn't damaged. Freya, no. Or at least you weren't damaged in a way that is provable by money damages. I think that's the bottom line. Actually, you got the restitution from the court. Do I read it correctly that you were also granted the restitution by the appellate term? Judgment, if I read correctly? Glendora, well, I got paid $1,580. No, that is not all of my money. It was some of it. Freya, basically you recovered whatever damage you suffered. Glendora is saying that she was damaged by this instant action that Lydia took against her. I'm not talking about the case where I appealed Judge Holden's decision. I'm not talking about that. I'm talking about this most recent case where Lydia Gallicano brought this action in small claims court, which was a dumb thing to do. And I say that it damaged me, and I say that I should be paid for those damages. And Judge Freya said not. As a result of the claim itself, Judge Freya said, all right, and that was the original claim of the landlord-tenant part of our court. The theory here, there is no theory here, or recovery of a sum certain, your equitable argument. Glendora, what was that theory? No theory of recovery of a sum certain, which is what small claims is actually for. They are a suit for money damages, and that's the only relief we can give on a sum certain on a provable sum of money up to now $3,000. And the nature of the counterclaim that you have really doesn't present claims for money damages. It is a claim of a higher and different nature, more appropriate to another court, not small claims action. They were also really responsive, I think, to the lawsuit that was brought against you. No, naturally they are. And I'm granting you the relief of dismissing it. And I'm dismissing it not only under Section 1810, but also under Section 1808, res judicata and collateral estoppel. Okay? Judge Freer said to me, I will write this up in a decision. You got to give me some time, organize myself. I'm looking for what she sent in the file on January 3rd. Just got it in the mail today. Make you a copy. She didn't send it to you, Glendora? No. Dated the 29th and received today. Well, if you can make her copy when you get a chance, she said to Trudy, so that the clerk, so that your motion is granted and the case is dismissed, okay? And to the extent that it can be dismissed with prejudice, it is dismissed with prejudice. Glendora, it is? Judge Freer. Yes, according to Section 1808, it is res judicata. You can't have the thing again. That means that Lydia Gallicano cannot bring any such action again. Glendora, 1808, res judicata, Glendora. It was really a queer thing to do. And Judge Freer says, I know, but something. Glendora, thank you, Judge Freer. Judge Freer, very good. 5:29 p.m., 9 minutes. And Glendora waited, and Trudy furnished a copy of Lydia's letter. And to this day, Lydia has not given me a copy of the letter, and that's against the law. That's against the CPLR. Anything you serve on the court, or anything you submit to the court, you have to serve onto the other side. And here's his letter. And here's what I think is wrong with that letter. First off, Lydia never served Glendora with a copy of this letter. The first Glendora knew of it was when the judge mentioned it on the court date from the bench, 5:20 p.m., January 4th, 1995. Lydia should have got a copy to Glendora before the court date. Lydia should have filed an opposition to Glendora's motion to dismiss on the basis of res judicata. She had plenty of time. Glendora's motion was served on Lydia December 16th, 1994, with a return date of January 4th, 1995. Glendora got a copy from the judge the night of the court date. Lydia should not have written a letter. She should have filed a cross motion. She was served my copy of my motion on December 16th. She had 3 weeks to oppose the motion. Lydia did not show up in court. Why? Lydia never gave the court a reason for not appearing. The rent was not wrongfully withheld. Glendora had proper reasons for withholding the rent, violation of warranty of habitability, the rent law, and violation of Glendora's right to peaceful possession. The landlord had no right to do what Lydia did, and Glendora correctly and properly withheld the rent. The violations did exist, and Glendora has proof and a witness. The violations are on videotape and have been seen on television all over. Naturally, the appellate term dismissed this case and reversed Judge Holden's decision. In addition to violating the real property actions and proceeding law with no 3-day oral demand, Lydia and her son-in-law lawyer, John Owenberger, failed to file a respondent's brief timely. Their brief was too late, and the appellate term automatically returns to a litigant an untimely brief. They had their chance to tell their story and get their brief in on time. Therefore, Lydia and son-in-law John Owenberger, lawyer, could not argue at the oral argument because they hadn't submitted no brief timely. They therefore lost another opportunity to argue their case. The allegation that the appellate term did not rule on the facts of the case goes back to their not submitting the facts timely. Lydia was afforded the opportunity to retrieve the money, but she muffed it twice. The court system is designed to allow someone, Lydia asked this question, the court system is designed to allow someone to avoid paying their rent because landlord neglected to make an oral demand for the rent 3 days before. Lydia has it wrong again. It was not a matter of sending a notice. It was a matter of making a 3-day oral demand, as the law says. Read it, Lydia. I thought that no motions were allowed, Lydia wrote. Well, that's wrong again. The second mistake was not submitting a cross motion. Your son-in-law lawyer should have told you that. Lydia has no requirement for legal counsel. She can do it pro se, just as Glendora does. Just read the books. She complained that in small claims court, that you didn't have to have a lawyer, and that if she had to have a lawyer, it would incur expense for her. Well, Glendora is saying she didn't have to have a lawyer. Go at it pro se. Her argument of significant expense to retain legal counsel falls based on a failing premise. She can do her own legal work as a pro se. The books are in the public library. There is no expense involved except for parking and copying. A reminder to Lydia Gallicano, Judge Freya not only dismissed your action, which was a crazy thing to do in the first place, but she dismissed it with prejudice. You will never be able to bring this action again. It is res judicata. It was res judicata when you brought it in October. And how come you filed the small claims in October and never served it until the day before Thanksgiving, Halloween to Thanksgiving? Whatever you submit to the court had to be served on the other side. Whatever you submit to the court has to be served on the other side. It is a law. And if you did not think it should be paid, how come you paid Glendora $1,080? No, $1,580. And you never thanked Glendora for letting you off without having to pay $300 interest. And you never thanked the sheriff for letting you get by without paying $300 in fees. Yours in truth, Glendora, Box 416, White Plains, New York, 10602-914-949-9495. The next time you get good tenants, be nice and don't try to boss them around. Judge Freya's decision. It's what they call a short form. Present, Honorable Duane Freya, Acting City Court Judge, Lydia Gallicano, Plaintiff, against Glendora Buell, Defendant. To commence a statutory time period for appeals as of right, CPLR 5513A, a copy of this order with notice of entry is this day served by mail upon all parties by the court. Index number small claims 4809-1994. Motion date January the 4th, 1995. The following papers numbered 1 to 19 read on this action to dismiss plaintiff's small claims complaint and to permit defendant's counterclaim to proceed as separate action. Defendant's notice of motion points 1 to 32, affidavits, saying that she read that. Exhibits 1 to 10. Noting the appellate term decision and order dated March the 25th, 1994, 1 and 2. There were 2 of those. That's what it says. Answering affidavits, letter dated December 29th, 1994, 1 page. I guess that's what it means. Upon the foregoing papers, the court decides and finds as follows. Upon the successful appeal to the appellate term of the judgment of this court, Judge Holden entered March the 22nd, 1993. Defendant's motion to dismiss plaintiff's small claims complaint dated October 19th, 1994 is hereby granted. In accordance with New York's UCCA, that's the Uniform City Court Act, Section 1808 and Section 1810. I think it's the Uniform Justice Court Act. The plaintiff is denied access to small claims because the underlying claim, a summary proceeding for non-payment of rent, was already adjudicated to have been improperly brought against the defendant under Real Property Actions Proceeding Law 711-2, a statutory requirement by the appellate term. Furthermore, there can be no other purpose at this time for plaintiff to commence a small claims action except to harass the defendant. The court having thus dismissed the complaint, it would serve no good purpose to permit the counterclaim to proceed as a separate small claims action. Defendant's counterclaim is denied and dismissed. This decision constitutes the order of the court, dated White Plains, New York, January 6, 1995. Duane Freya, she did okay. She did it 2 days later. Acting City Court Judge, please take notice that the within order has been entered this 9th day of January 1995, and a copy served by mail upon you simultaneously, herewith by me at the below addresses. Marie Gupta, Chief Clerk, White Plains City Court, to Lydia Gallicano, 42 Longview Avenue, White Plains, New York, 10605, to Glendora Buell, Box 416, White Plains, New York, 10601. And the matter is closed. Gotti said to Deborah, these pictures don't do you justice. These pictures don't do you justice. And Deborah says, it isn't justice I need, it's mercy. Little boy said to his daddy, I got 100 in school today, and Daddy says it's about time. What'd you get 100 in? A little boy, 50 in reading and 50 in spelling. Cano, 42 Longview Avenue, White Plains, New York, 10605, to Glendora Buell, Box 416, White Plains, New York, 10601. And the matter is closed. Gotti said to Deborah, these pictures don't do you justice. These pictures don't do you justice. And Deborah says, it isn't justice I need, it's mercy. Little boy said to his daddy, I got 100 in school today, and Daddy says it's about time. What'd you get 100 in? A little boy, 50 in reading and 50 in spelling. And when Diane said, I'm not going out with you this weekend, Donald says, this is terrible. He says, you've ruined all my weekend plans. He says, everything is ruined because you're not going out with me Friday night. He says, what'll I do with my weekend? And his girlfriend says, put a hat on it. Spite and malice of the ruling of Judge Nicholas Colabella and of his revengeful law clerk Raymond Powell and his court clerks T.J. Mallon and Steve Kellner. Nothing is happening on Glendora versus the Fund for Ancient Courts, Elizabeth Hubbard, Michelle Mayapath, Alan Beck, and Edmund Purvis. Nothing has happened this week from January 5th to January 12th, 1995. The Glendora TV log, what happened from Thursday to Monday, January 5th. Let's see. The editing last Thursday at TCI went very well. 16 program number 1,648, 49, 50, 51, and 52. 3/4 inch Super VHS and VHS. Mostly Friday was spent trying to resolve this Gelman thing, going through the audio tapes, listening to the audio tapes, finding the audio tape conversations over the telephone that proved Gelman did what he did. And it takes 7 hours to listen to 5 tapes. Each tape is 90 minutes long, and to check it out to see if there's any Gelman evidence on it. The work is way behind. Church was Sunday. Sunday on Gelman, we were 8.5 hours the day before, and something like 9 hours on Monday, and something like 14 hours on Tuesday. It was the court date. The United States Supreme Court petition for writ of certiorari got out on Tuesday. Canon called me and said that they will give me a free Canon cartridge to make me feel better, and it's worth about $100 because my PC 310 Canon copier is on the fritz, and it went on the fritz only a few months after I bought it. And the reason I had to buy it was that my first Canon copier, the PC1, went on the fritz and cost $178. So they called and told me to get the proof of purchase date in the warrant so that the warranty would pay for it. And I loaned the first Canon copier, you know all that, to Robert Perry. It's hopeless trying to lose weight. At 8 p.m. Monday nights I always watch Nanny. And my program on White Plains Cable TV has been switched from Mondays at 5:30 p.m. at my request because there's too many Mondays off. People take too many Mondays off, lazy, aimlessness and sin. And so my program doesn't get cablecast on Monday, so it's been moved to Thursday at 5:30 p.m. It should be moved to prime time. Okay. There's a whole bunch of legal papers that have to be done. I had to pay $1 for copies of the police reports and the White Plains records. And let's see if anything else went on worth noting. The temperature has been wonderful. We had our first snowstorm on January the 5th. No. January the 11th, because today is the 12th. The first snowstorm wasn't until the middle of January. Remember it that way, 1995. Our weather's been beautiful, and even this snowstorm isn't much. It's really just a ground cover. Who are upset with the things that certainly do upset us all about the lawyers, the crooked lawyers, and the corrupt judges. Call this number in Long Island, 516-777-7307. And then in Westchester, call this number. The Center for Judicial Reform is 914-422-1200. To the stealing of my VHS videotape by Michael Gelman and his refusal to make good on it, let me tell you 3 jokes. The boy went to work for Jack Lemmon, the movie star, and he liked the job very much, but he didn't, and his job was to help with opening the fan mail for Jack Lemmon, but he liked the job very much, but he didn't like it when his family called him a lemonade. Folks, do you know that you can pick a day when you think you will die? Pick a day that you think you will die, and then you can get prepared for it. And then if it doesn't happen, you can start life all over again. The teacher said, draw a picture, and the little girl brought up a blank sheet of paper. And the teacher says, what is that? And the little girl says, that's a cow eating grass. And the teacher says, but there's no grass. And the little girl says, well, the cow ate it all. And the teacher said, well, there isn't any cow. And the little girl says, when the grass was eaten, the cow left. The policeman said, he stopped the motorist and he says, what did your speedometer say? And the motorist says, my speedometer doesn't work. And the policeman says, what? You don't have a speedometer? How do you know how fast you're going? And the man says, well, at 40 miles an hour, it rattles, and at 50 miles an hour, it shimmies, and at 60 miles an hour, it stops. And the report on the bad action of Michael Gelman is that on January the 5th, Thursday, it took 2 hours to videotape the evil that he has committed and to edit it and make it a public record. And at 9:30 a.m. on Friday, we picked out the tapes to listen to for Thursday. We had to make up for Thursday, and we had to make up for Wednesday. And we have spent, let's see, here's 142.5 hours at the close of Saturday. Most of the day was given to Gelman, something like a terrible amount, like 8.5, 9 hours. And on Sunday, we listened to 5 audio tapes and checked them for the evidence. And we've decided that it's necessary to put all of the audio tapes, about 400 of them. That's the large size audio tapes, not the micro cassettes. It's 600 tapes altogether. And so by Sunday, let's see, we came across some interesting things. The conversations with Austin Hearst, who has died, and William Randolph Hearst, who has died. Conversations with them, they were interesting. Let's see, by Sunday night, I think we had spent 151 hours on Michael Gelman's destruction of Glendora's property and refusing to do anything about it. And as I say, we had to put all these audio tapes in order. There's 432 of the larger tapes, 462, and they all had to be labeled and dated. Let's see what happened. Okay, we closed the week out with 161 hours. The costs on it have been $37. Monday was another day shot by Michael Gelman, and then Tuesday was Gelman all day. And here's the small claims rules. There's only 14 sections to the Small Claims Act. And January the 10th was court day. We left at 4 p.m. and to go to Center Street down near Foley Square in Manhattan to the city court. After spending most of Tuesday screening 5 audio tapes to find Gelman evidence, and then I went through the 14 or 15, no, I think it's 28 tapes I found that have Gelman evidence on them, and went through those and queued them all up for court. And that same day, on our way to Manhattan, we served and submitted the petition for writ of certiorari to the United States Supreme Court. So we went from the United States Supreme Court to Small Claims Court. Let's see. We stopped at the Seventh Day store at 40th and 5th to get some vegetarian meats for the cats. And it was a terrible job for Franklin to bring in 4 boxes, each box this size, loaded with audio tapes. I showed those to you last week. And 4 such boxes had to be brought into court. We would have brought them in anyway, but it was in the subpoena, Ducis Tecum, to bring those in. And so we did. Let's see, we were called by 6:40 p.m. The court door opened at 6:25 p.m. There were at least 300 people there. Many people were standing. A New York State court officer started calling the calendar. And at 6:40 p.m., Glendora versus Michael Gelman was called. Glendora said, "Plaintiff ready by the court," and we could not distinguish what the defendant said. And a woman was sitting at the bench when the litigants filed in, and that woman turned out to be wearing a black robe, and she turned out to be the judge. Her name is Marilyn Schaefer. And a woman sitting in the front row with me was truly distraught. She was suing for $700, and she says, "I'm suing a billionaire." DiGiulio sat a long way from us and did not speak to us, nor have any eye contact with us. Christopher DiGiulio is the lawyer that Michael Gelman hired. So we go to Small Claims Court in Manhattan 3 times, and we have 3 different judges so far. The boxes of audio tapes were within DiGiulio's view at all times. We were called. DiGiulio started his litany of lies. He said that Glendora had been paid. He said that the tape was returned to her. He said that she would not settle. He said it was chattel. Glendora objected to all of these lies, and Schaefer told Glendora not to speak. And Glendora was gagged, and when Glendora got a chance to speak, she said she had never been served a copy of defendant's answer. Can you imagine that? Judge Gans told DiGiulio to have his answer served on Glendora by the 5th. I had gone to court and I had never had the answer. And he handed one to the judge there, but he had never served an answer to me, so how could I answer it if I never got one? It was my motion for summary judgment, and DiGiulio was to oppose that, and Glendora was to have a reply affidavit. Judge Schaefer did not seem to care. DiGiulio lied that he did serve it on Glendora, but Glendora never got anything from him. Glendora said she should win by default judgment. Schaefer did not attend to that. Schaefer was pro-lawyer and anti-pro se. She asked DiGiulio what this was about. DiGiulio did pretty well at first, but then he fell off the edge with consecutive lies. Glendora said that she had never been given a release to sign, that she never saw the release, that Judge Schaefer did not seem to care. Judge Schaefer said that Glendora should have been there last night, January 9th, return date of Glendora's second motion. Glendora was aghast, and Schaefer said, yes. Glendora apologized. Schaefer said, we put it over, knowing this, the first motion for summary judgment was scheduled for tonight. Glendora felt very bad that she had missed last night. Glendora said, in my court, they do everything by submission on paper, and where I'm not used to appearing. Glendora protested again that DiGiulio had not served her answer to her motion for summary judgment. Schaefer says, what are all these motions? This is a small claims court. Glendora did not get a chance to answer, but she notes here that the defendant via Joyce Bigelow the first night, November 1st, led off with a motion to Judge O'Connor. Judge O'Connor denied it. See Glendora's motion papers and her chronologies. Glendora said to Judge Schaefer that Judge O'Connell had already ruled that this was not a return of chattel case with 3-year statute of limitations, but that it was a breach of oral contract. And Schaefer said, where is this? Where is such a record? What another judge ruled, as she flipped pages. And Glendora knew that it was right in front of Judge Schaefer, and then it became clear to Glendora that Judge Schaefer had not done her homework and had not read the papers. Glendora complained that she was not getting substantial justice. Glendora complained that she was not getting substantial justice. She said, quote, small claims is supposed to be a speedy resolution to a dispute. Judge Schaefer did not respond. Glendora also complained that DiGiulio was making her a victim of delays and obstacles contrary to the Small Claims Act, Unified Justice Court, Article 18. Judge Schaefer did not respond to this. Judge Schaefer asked, what is this notice to admit? Yours, she said to DiGiulio, and Glendora said, no discovery in small claims. Glendora said again that she had never been served an answer to her motion for summary judgment, that DiGiulio was in default. Judge Schaefer told DiGiulio to give her a copy and told Glendora to sit down at the table and answer it. Franklin and Glendora sat down at the table, and DiGiulio began a frenetic attempt to find another copy of his answer he had handed into the court but had not served on Glendora. This is not right. Judge Schaefer should not have let this go by. As DiGiulio stood at the table, his front toward us and his back toward the judge, Glendora said to him, you lied up there at the bench 12 times, and said more. Then she looked up and Judge Schaefer was looking at her, so Glendora stopped talking. After 3 minutes of hunting, DiGiulio said, I cannot find another copy. You can read mine. Glendora started opposing his answer in writing on another sheet of paper, but then gave up at that, so she opposed the rest of it in the margins of his paper. She objected to all his lies in the affidavits of Gelman and Norman. The affidavits of service by Bigelow says it was served on the due date, the 5th of January, yet there is a notary on Gelman's paper for the 6th of January. So you can see that that's dishonest and it's crooked. Insert, Glendora asked that the bench show proof that you served it on Glendora, and he did not declare under penalty of perjury, and how could he? The paper called a cross motion bulges with lie after lie. Remember, defendant was anxious to settle on December 1st, 1994. That shows his guilt. That shows Gelman's guilt. That shows he has no defense. For the other objections to DiGiulio's cross motion, see Glendora's reply affidavit. There were about 20 objections. DiGiulio sat on the front row bench all the time Glendora and Franklin were answering his cross motion. It was very hard on Franklin, 75 years old, to lug in 4 boxes of audio tapes from the car, go through security 3 times, and bring the boxes of audio tapes into the courtroom. It is not fair. Opposing the cross motion is their reply affidavit. We were about 20 minutes. The boxes of audio tapes were behind DiGiulio and in front of DiGiulio. The file drawer was wide open with about 200 microcassettes piled high. The other 3 boxes were 4 feet high behind him with Glendora's coat on them, so he had to see them. And these are the ones that he had the subpoena Ducis Tecum served last week to produce, which I would have produced anyhow. They're my evidence. When we finished writing our notations of his lies and deviousness, Glendora went to the New York State Court officer standing in front of the bench and said, "We are done." We waited, and then we were called a 3rd time. Glendora handed her answers scribbled on the DiGiulio cross motion to Judge Schaefer. Judge Schaefer said, "I am not used to having things thrown at me." This was prejudice. Glendora had not thrown it at her. Glendora said she was sorry, picked it up, and laid it again on the bench. Glendora, of course, was right about the wrong done her, that DiGiulio was getting away scot-free after he defaulted in not answering timely Glendora's motion for summary judgment, as per the calendar set forth by Judge Gantz, December 5, 1994, at this same bench. Judge Schaefer laid our hard work aside and asked what this case was all about. DiGiulio did a summary that was fair up to a point, but then went afoul. Glendora had to work to get to Judge Schaefer's attention for her rebuttal. Glendora said it was not to play her videotape on TV. It was not even broadcast standard. In other words, DiGiulio, who says he's familiar with the facts and circumstances, that tape sent to Michael Gelman was not for Michael Gelman to play on TV. That tape was to see the concept of jokes, Glendora, a cheerful look at life, to see if it would be a regular thing on TV, or if it would be on TV the concept of the jokes, but not that tape. That was only a demo tape. It was not even broadcast standard. Glendora later found a happy home for her jokes. Glendora Cheerful Life, Xerox sponsored them, General Foods, Quaker Oats, Polaroid, Texaco. So I did find a happy home for those jokes, and they should have been on Regis to cheer up that audience, but it was mishandled by Michael Gelman. Glendora rebutted other lies and smoke screening by DiGiulio, but DiGiulio started talking again. Judge Schaefer listened. Glendora had to return the judge's attention to Glendora's right to equal time. I hadn't even finished. Glendora was not getting equal protection of the law, 14th Amendment, which applies to the states, and this was a state court by the Unified Court System Act. Judge Schaefer looked at DiGiulio plaintiff and I don't know. Judge Schaefer looked at DiGiulio and asked plaintively, I guess that's what it is, will you settle? DiGiulio obstreperously said, no, never. We will fight it all the way. DiGiulio lied that Glendora had already got paid. She got paid by Michael Katz when Michael Katz was working for Arts and Entertainment Cable TV, which is in a different entity entirely from ABC, Live with Regis. This had not to do with Michael Gelman. Katz lost a similar VHS, but this loss was by UPS, United Parcel Service, and UPS paid for losing the tape, and this story is all delineated on the audio tapes Glendora has been screening 8, 9, and 10 hours a day since December 27, 1994. Glendora said to Judge Schaefer she would send her reply affidavit to Giulio's cross motion, and Judge Schaefer said, no, enough papers. Well, it's going, because I certainly have to refute all of DiGiulio's lies. Gelman said in the affidavit included in the cross motion that he did not say he would return the tape and that Glendora had asked him to return the tape. Now this is stupid and it's crooked. It is ethical to steal another person's property or to lose it or to destroy it. That's ethical. How can you not return to a person his property? You know, what kind of ethics, what kind of an upbringing did Michael Gelman have? We do not live by the Golden Rule, the Beatitudes, the Ten Commandments, the Judaic Code. This was a dumb thing for Gelman to say, and lays himself wide open for his lying, stealing, and cheating. At first, Glendora went to small claims court November 1st, ready to go before an arbitrator and have it over with. Now she gets angrier and angry at the injustice and at the deception and at the deviousness, and is determined to go to the appellate term if necessary in the New York State Court of Appeals. There is no way Glendora will not submit her reply affidavit to the court. Having never been served, Glendora has to answer in writing by typewriter, legibly, her opposition to DiGiulio's crooked cross motion. All that Glendora wrote in the margin under duress at the table in front of Judge Schaefer's bench is cogent delineation of what really happened, but it had to be scribbled in a hurry, and Franklin says it is illegible. Justice is justice, right is right. Glendora is not going to let this go by. About Judge Schaefer's comment on motions, Glendora won a case in White Plains Small at Claims Court just 5 days ago on a motion. Claimant's action was res judicata by Uniform Justice Court Act, Article 18, Section 1808 and 1810. The motion got the case dismissed, and with prejudice, the judge, also a woman, ruled that the appellate term, 9th and 10th districts, dismissed the action a year and a half ago. Judge Joanne Frea's short-term decision is enclosed. Glendora also has a transcript of that proceeding, what happened in Judge Frea's courtroom. January the 4th, 1995, Wednesday, 4:30 to 5:30 p.m. DiGiulio lied that the tape was worth $8. The tape is worth $8, maybe if it's empty, like DiGiulio's mind and soul, but the production of the TV tape is worth $120, and Glendora told Judge Schaefer that. ABC TV at the time was charging Glendora $500 a dub. DiGiulio tried to lie that Glendora had brought an action against Michael Katz, the tape Glendora sent him having been lost, but this was not an action. Glendora simply told him, Michael Katz, that he had not returned it, and his people found out that UPS had lost it, and UPS made good. What is DiGiulio's soul worth to lie like that? DiGiulio lied that he tried to settle the matter amicably with Glendora. Glendora said he was anything but amicable. He was abrasive. DiGiulio could never be amicable. He might be obsequiously amicable if he wanted something badly enough. DiGiulio lied that Glendora was abusing the process. This is typical of liars. They always try to put the blame on what they are doing on somebody else. It is a bad record. It is DiGiulio who is abusing the process. And Glendora will make it as public as she can. Glendora will read the record on her TV show on 11 different cable systems. DiGiulio was lying, trying to make the judge think that Katz paid for Gelman's tape. What a twisted mind DiGiulio has. There were 3 tapes involved. The one Glendora sent Gelman following the Christmas 1989 telephone conversation, the one sent to Michael Katz long before, and the one sent to Calvin Norman. It looks like Glendora will amend her complaint for a second $190 damages for the one sent Calvin Norman that was never returned either. DiGiulio claimed chattel again, but this was not the case. Res judicata and collateral estoppel by way of Judge O'Connor, November the 1st, 1994. Judge O'Connor said breach of oral contract. DiGiulio lied about no affidavit of service of the subpoena Franklin served on Gelman in the court record. It is in the court record and has been all along. It was sent to the court the next day after Franklin served it on fugitive Michael Gelman. Glendora will release Michael Gelman as soon as he pays $190 for the first tape, the tape Glendora sent Michael Gelman the day after Christmas. She will release him from that action, and that action only, small claims number 8347 of 1994. She will never sign a release that chews up in medieval fashion her rights for everything else. DiGiulio said he would never settle. He said he would settle 8 times from December 1st to December 5th. Judge Schaefer asked him the words, "Can you settle it tonight?" DiGiulio refused. Thus he makes the delay and makes the obstacles and wastes scant judicial resources, quote unquote. courts will. What a vortex. This was the protest to the unjust decision by Judge Wood, really by his law clerk, Paul Carlucci, that was sent all over New York courtland to Governor Cuomo and to Pataki and to Carlucci. And it is only common sense. A case needs continuity. Now, Franklin thought Judge Schaefer did a bad job. Glendora asked him why. Quote, "She does not pay attention. She gets upset too soon. She doesn't want people to talk. You will never get justice from that judge." Glendora got a headache in that hot, crowded, stuffy courtroom with all the noise and confusion, trying to hear the judge, trying to keep the record straight with DiGiulio's lies, and with the court clerk bellowing at the microphone only 5 feet from the bench, Judge, DiGiulio, and plaintiff Glendora. It was a good thing Glendora had spent an hour reading Article 18 before she went to Small Claims Court. It is a very simple law. It only has 14 sections. That's the Small Claims Act. These trips to Small Claims Court in Manhattan are a hardship on senior citizens just because Michael Gelman wants to lie, steal, cheat, and cover up and run away from justice, and just because DiGiulio wants to chalk up lawyers' fees from ABC cap cities. Franklin is 75 years old and Glendora is 66. Franklin is a D-Day veteran, yet the court is insensitive to all this. As Glendora has said, a judge has to be an expert to be qualified to be a judge as to who is lying and who is telling the truth. A judge has to be an expert as to who is lying and as to who is telling the truth. These trips to Small Claims Court in Manhattan over and over are a strain also on our 40-year marriage, celebrated Christmas Day 1994, 5 years after Michael Gelman went back on his contract with Glendora. DiGiulio looks ridiculously small time in Small Claims Court, and so does Gelman. Although they do a wonderful job taking care of 300 people in a night, it does seem the judge should not be in the same room with the clerk, bellowing at calling the calendar. It does not seem, although they get the job rolling that way, the judge and the litigants at her bench should be in a separate room. Settled. It must be hard to be a judge under those circumstances. We ask, why didn't she do her homework and read the papers before she got to the bench? Judges are required to be fully aware of the facts and circumstances. So is DiGiulio, but he is not. This may be, however, just a guise. Judge Schaefer led off with, "What's this all about?" And DiGiulio answered, and Glendora should have. Glendora has been saying for 4 months she wants Gelman to appear, habeas corpus. He will certainly have to show up for the trial. Glendora asked Franklin what was DiGiulio's motive to keep this going. Franklin said, "He is peeved you are so keen. Your being determined irks him." Glendora says DiGiulio interjects his personality into the case instead of doing what is best for his client. He is his client's own worst enemy. He is a worse adversary than Glendora. Glendora is only trying to make his client do what is right. DiGiulio is trying to make his client do what is wrong. Why are the courts so sure they have a better solution to a dispute than a punch in the nose? Gelman, ABC Cap Cities, Warren Buffett, Thomas Murphy have to know that DiGiulio was not very well prepared, showing up with no extra copy of his cross motion, knowing full well he had not served on one on Glendora in time for the court date. They also have to know DiGiulio is doing a terrible job representing them. They would be better off going pro se. They are all at sea, Franklin says. DiGiulio did not bring up day in court again. Did not bring up the day court again. You remember before he asked to have it transferred to day court. Well, he didn't bring that up again because that was res judicata by Judge Gans, December the 5th, 1995. The clerk asked Franklin 3 times to move over toward Glendora on the plaintiff's side, away from the center of the table in front of the bench. It is bad when you go up to the bench. You have no place to sit and no place to spread out your papers in front of you. You have to hold them in your hand. It will probably be a fourth judge, a different judge for the trial. Franklin says O'Connor, of the three, was the best. Franklin says that Judge Schaefer is impressed by a lawyer, even though small claims is a pro se's turf. What was the time? 6:25 p.m., doors open. 6:35 p.m., called to the front row. 6:50 p.m., called to the bench. 7 p.m., sat at the table and refuted DiGiulio's cross-motion lies. 7:25 p.m., back at the bench. 7:35 p.m., left the bench. It must have cost Warren Buffett $150 to have DiGiulio have served on Glendora the subpoena Deuces Takem. This is a $120 lawsuit. It must have cost $150 to serve that subpoena, to bring in my audio tapes and my papers, which of course I'm going to bring in anyway. The subpoena Deuces Takem was for papers and tapes that Glendora has produced every time she went to court and every time she submitted papers by mail. But DiGiulio got paid for looking the form up in the CPLR, Article 23, and filling it in, and he filled it in wrong. He said in the forenoon, and it is in the evening, and having it served, yet DiGiulio cannot serve his cross-motion timely on Glendora. But Glendora and Franklin brought the 4 boxes of 600 audio tapes and the videotape and the tape players to the court, and dumb DiGiulio never paid any attention to them. It is a waste of labor, money, and brains. He never even mentioned the tapes. DiGiulio did not act on good faith on the subpoena Deuces Takem. He brought no audio player nor any video player to the courtroom January 10, 1995 to hear the audio tapes nor see the videotape. Here is some small claims case law that the defendant should be appraised of. The court shall conduct hearings upon small claims in such manner as to do substantial justice between the parties according to the rules of substantive law, and shall not be bound by statutory provisions or rules of practice, procedure, pleading, or evidence, except statutory provisions relating to privileged communications, and something that doesn't apply. In case of conflict, the provisions of the small claims law shall apply. Here's a case. The trial court must be given wide latitude and discretion in the conduct of the proceedings. And about arbitrators, Section 1804 says to do substantial justice in accordance with the principles of substantive law and are not bound by any rule of procedure, allowing reconsideration by the arbitrator to correct error. Don't go before an arbitrator, because then you can't appeal his decision and it's over. Wait for the judge. Although hearsay, since in small claims hearings the court is not bound by rules of practice, pleading, or evidence. Hearsay is acceptable, it says here. Defeat the purpose of the Small Claims Act by causing inconvenience, increased costs, and prolonged proceedings. And that's exactly what DiGiulio is doing. Prolonged proceedings, inconvenience, and increasing costs. Glendora wishes she had a defendant's right, small claims, to have a jury trial. This is Ginny Cat. Hello, Virginia. DiGiulio included a witness fee of $15, but no travel expenses for 23 cents per mile. It is 80 miles down there, $9.20. So far, this Gelman tortfeasing has cost Glendora and Franklin $46, and we have seen no justice. DiGiulio's lie about statute of limitations of 3 years is crumbled by the fact that this is an ongoing action. Glendora has made a demand for the, Ginny just lay down and went to almost asleep, has made a demand for the $120 every week since the spring of 1990. These demands were oral and are on audio tape. Glendora had them queued up for the judge to hear on January 10, 1995, Tuesday, but it never got to that. Glendora has found 28 tapes so far for the judge to hear, each segment 1 to 3 minutes long. Michael Gelman, all the years Glendora made an oral demand for the $120 every week, never contested nor denied that Glendora had submitted a tape to him. There is no dispute of this fact. 2 judges have looked into these lawyers' soulless eyes and said, for $120? They have no pride left, no self-respect, these lawyers. They have sold their souls. All they have in their eyes is dollar signs. Gelman has failed to appear in court 3 times. The small claims law states that such practice, procedure, and form shall differ from the practice, procedure, and forms used in the court for other than small claims, notwithstanding any provision of law to the contrary. These shall constitute simple, informal, and inexpensive procedure. That's what the small claim should be. Glendora has been robbed of her right. For the prompt determination of such claims in accordance with the rules and principles of substantive law. Just let me say again, prompt determination. What have I got? The start is September 30th, and here it is, January the 12th. This is the Uniform Justice Court Act. Glendora's small claims rights have been denied. Glendora is going to notify Mr. Pendarvis at the FCC of Gelman's fraud and illegal and unethical action as a license deterrent for Frequency Channel 7 New York, license renewal time. New York State adheres to the majority view that a contract oral is as valid as a contract written, that a contract can be made over the telephone, as this one was, that courts favor the keeping of contracts for the stability of society, that a person like Gelman has to do what he says he will do, whether he intends to do it or not. And what is this? Oh yes, this is what Franklin wrote. This is some of his shorthand up here in the corner. His newspaper man's shorthand. Judge said that Glendora was supposed to have been in court yesterday, January 9th, for her motion. They held it over, but she made no decision on it. That was the motion for judgment. Judge had a cross motion from DiGiulio to answer to Glendora's motion. We said Glendora had not received it, that it was overdue. Judge asked DiGiulio to give Glendora a copy so she could reply. DiGiulio had only 1 copy. Glendora made notes on it. When she finished, she told the clerk she was ready to resume with the judge. Judge wanted to take Glendora's notes as her reply, although the judge won't be able to read them. Glendora said she will prepare a formal reply because there is lots to answer and refute. Judge seemed willing to get along with what she had, even though that wouldn't be fair to Glendora. DiGiulio told the judge he would not settle the case. He asked the judge if we would be notified of a trial date. She said yes. Judge was hostile to Glendora and deferred to the lawyer. She didn't seem to have read any of the papers, and she didn't address the matter of rulings on them. That's just as well. They would have been against Glendora. Glendora pointed out a few facts that DiGiulio had wrong. Judge didn't seem to be absorbing much. 3 sessions and 3 different judges, Franklin writes. Nothing accomplished on January 10th. DiGiulio was late with his paper. Affidavit of service said sent to Glendora January 5th, but Gelman's sworn statement was notarized January 6th. This is the Center for Judicial Reform, and this is Americans for Legal Reform, or for Judicial Accountability. Excuse me. This is the list of audio tapes and the dates at which I screen them. Each one of these, each line is 7 hours work. Here are the audio tapes that I found. There's 3 pages of these folks. Here's page 2. And here's page 3. And Jeannie, you just don't care. Here, Jeannie, look up to the folks. Look up. Yeah. Dear, look at that great face and those cute little hands. And those sharp little teeth. Glendora asked Judge Schaefer, "Will you be our next judge?" And she said, "I don't know if I will be that lucky." Something transpired at the bench between Glendora and Judge Schaefer that struck Glendora as amusing, and Glendora laughed. When Glendora laughed, Judge Schaefer laughed too. Judge Schaefer said yes to DiGiulio on something. Glendora said to Judge Schaefer, "What did you say yes to?" And Judge Schaefer said, "Will be noticed for a trial date." It was a big job to take the 4 copy boxes full of audio tapes back to the car. They were heavy and bulky. DiGiulio's work is bulky but has no weight. Glendora and Franklin watched DiGiulio exit the courtroom as they did December 5th, 1994. The time was 7:35 p.m. Glendora had to go and get her 2 audio players from security. All the New York State security officers that night were from Staten Island. When Franklin went through first, one of them asked, "Where's your partner tonight?" And just then Glendora appeared, and he says, "There she is." They liked the jokes, just as the live audience of Regis would have liked the jokes. 7:41 p.m. we pulled out of the parking space. Do you know something? You cannot buy a cup of coffee all the way from 111 Center Street, Lafayette Street, to the Brooklyn Bridge, to the FDR entrance, all the way up to Willis Avenue, all the way on the Deegan until you get to the wealthy Westchester, where all the rich people live, and the Cross-County Shopping Center. F needed a cup of coffee and had to drive all that way without any nourishment. The temperature was 31 degrees. At 8:01 p.m. we arrived at Finest with a half hour to go. From 4 p.m. to 8:30 p.m. is 4.5 hours times 2 people equals 9 hours, all because of the anti-ethics of liar, thief, and cheat Michael Gelman and Chris DiGiulio. And this is on top of 5 a.m. to 3:30 p.m. equals 8.5 hours Glendora spent on screening the Michael Gelman tapes, which nobody at court ever paid any attention to. The total is 17.5 hours this day on the anti-ethics of Michael Gelman. This hurts a person's business excruciatingly. This time, Glendora should have spent getting business for Glendora TV ads. And also, Gelman was the cause of Glendora's failing to see A Chat with Glendora on TCI cable TV 9 to 9:30 p.m. in Westchester, Channel 8. With all this, Franklin was able to serve and submit, notarize and print, stuff and seal Glendora's petition for writ of certiorari to the United States Supreme Court. This was a day from the sublime to the ridiculous. We got to bed an hour late because of the Gelman torts. Glendora awakened at 2 a.m. until 3:20 a.m. thinking of the injustice. On the next page is Franklin's account of what he saw. I just read that to you. Franklin is a retired newspaper reporter, 37 years. He knows Calvin Norman. Following Franklin's reports are 2 pages of more people disillusioned with lawyers in the courts. Next, Glendora will write her reply affidavit to the cross motion of Chris DiGiulio. I didn't get a chance to do that yesterday because of the excitement of having won the case in the United States Court of Appeals. I won the first Cablevision lawsuit. I won it. Judge Bryant's bad decision was vacated, and the case is remanded to the district court. And so that's the first Cablevision lawsuit I won, the second one I've won. The third one is going to the United States Supreme Court. So here is DiGiulio's cross motion, and it's filled with many lies. And this morning we started writing out the reply affidavit to set the record straight on that. So that will have to be written, and then it will have to be typed, and then it will have to be submitted. Somewhere here, there should be a tally of the number of hours to date spent on the anti-ethics of Michael Gelman. One of the things this affidavit says is that Glendora didn't tell him to send back the tape. And so you have to be told. A person of that caliber has to be told that you don't ruin another person's property. You return it to them. You have to be told that, right? If your mother and father didn't tell it to you, and if your religion didn't tell it to you, then at this time and at this age, Michael Gelman has to be told, you return somebody's property. I can't find the number of hours, but I think it's about 170. 170 hours, and it's $46, was it? Yeah. And that's Glendora versus Michael Gelman. What happened from January the 5th, 1995 to January the 12th, today, 1995. You going to say bye-bye to the peoples? Okie dokie. You're going to go to sleep. And now we will ask Franklin Buell to sing the closing hymn for you. Sing our closing hymn.
Faith of our fathers living still, in spite of dungeon, fire, and sword. Oh, how our hearts beat high with joy whenever we hear that glorious word. Faith of our fathers, hold
Glendora, chat with Glendora, Glendora TV ad, Glendora Happy Book. Let's see what else. Glendora Cheerful Look at Life. We won a big lawsuit today. The United States Court of Appeals vacated Judge Bryant's decision on Glendora versus Cablevision. Freedom of speech and violation of 531E, no cable operator can exercise editorial control over public use of channels. Take care. On the telephone answering machine Friday night, January 13th, Friday the 13th, when A Chat with Glendora was on TV in Nassau County. And Ginny is playing with a lens cap. Press the smart button.
And I find your show very interesting, and I saw the thing for your free happy book, and I'm very interested in that. If you'd send that to me, I'd love to read it. My name is William McCaffrey, McCaffrey. My address is 9 Whitney, WHITNEY Road, Bayville, New York, 11709. All right, I look forward to it. Thanks a lot. Bye.
Good for you, Mr. McCaffrey.
Hi, my name is Bill Garrison, Garrison, 13 Seawall Lane, Bayville, Bayville, New York, 11709. I would like a free happy book. Please send me a free happy book. Thank you.
Hi, Glendora. This is Gina and Ed from Long Island. We're very upset with you because we were all excited to watch a Padre Pio special on television, and your show just preempted it. And I think that's very upsetting, and I think that you should talk to Cablevision and make sure that they don't have your show preempting shows like that, because that was a very important show about a man who was just me and a saint. And I think it's awful that your show preempted it. Ed, you have anything to say? My husband is very upset. He was excited to watch this program all week, and your show just preempted it. So please be aware that your show might be taking the place of some very valuable shows that need to get out to the public. Thank you, and have a good day.
Good going. Good going. Two syllables.
Glendora, this is Michael. You can reach me at 516-564-9753. I'm an attorney from Nassau County watching your show as we speak. Please call me. I'd like to discuss what you're saying. Thank you. You gotta get a life, you crazy old fat. Get off my television. If you're gonna be there, at least have the decency to hang the American flag the right way. Read a book on flag protocol. And get a life. That's okay. Get help.
So, those calls were on the telephone answering machine Friday night while A Chat with Glendora was on Channel 25 at 10 p.m., Cablevision Nassau, and also Babylon, Islip, and Huntington. Imagine this, it was close to 60 degrees, Friday the 13th, 1995. And here's the window open, and there's Katie Cat. And here's Ginny Cat. And this car should be fixed. You hear it? You see it? And Theo just got in the car, and before he got into the car, he taunted Glendora by waving at her. Okay, this is the car that should be fixed. Noise pollution and air pollution. And this is on Saturday. Nella is driving. Her son Theo is in the front seat. That's the window to the east, and this is the window to the south. Okay, now there were 4 horns. That was 4 horn blasts. The weather's beautiful. It's like 50 degrees. Nella went by this window last night at 10:48 p.m. and says, "Hi, Glendora. How are you?" And woke me out of a sound sleep, and then she punched my window twice. Let me show you what time it is. That's the CompuTech. Go on out, Katie. Go on out, honey. It's a January thaw when we haven't had any freezing. Ginny does this a lot. She goes to sleep with her forehead on the pillow. I can't get you very good light, because if I move, she'll wake up. But you see how she goes to sleep with her forehead down on the pillow. Yeah, that's the end of it. We just made that. Hi, Ginny. Hi, Ginny. That's very cute how you do that.